All right, we'll start now. So thank you all for joining. My name is Conan Crown. I'm a partner in the intellectual property group at Akin Gump, and with me are a number of my other partners here at the firm who handle ITC, different aspects of the ITC process, and they'll share their views with us regarding their contribution to the whole ITC process. Next slide. So on the agenda today, we'll have a brief introduction to the ITC and an overview of trade secret investigation and the trends that we're seeing both at the ITC and broadly in the U.S. district courts. We picked the LG Chem case, the 1159 investigation, because it was a trade secret case, the most recent one ruled on by the commission, and it also had other components that were relatively rare. In that case, there was a default judgment for contempt of discovery order and spoliation, it happens maybe 5 times in the last 5-6 years. So that's a relatively rare circumstance, so that we thought that was worth talking about as well as that case dealt with the domestic industry of electronic vehicles and their strong public interest in that space. So it had a lot of involvement by Congress, other state governments, federal agencies, and the president themselves, or the USTR, U.S. Trade Representative. The next section we'll talk about is public interest factors, particularly with respect, generically, and with respect to the 1159 investigation and presidential review, again, generically, and with respect to this particular investigation, and then customs and border protection, again, in general, and then also what would be generally good practice to do for any ITC investigation that looks like an exclusion order is coming down, whether be it the complainant or the respondent side. And then and finally, as far as different agencies or courts, the appeals before the appeals from the ITC at the federal circuit. And then finally, we'll have a quick bullet points on strategies and takeaways from trade cases as well as ITC practice. Next slide. So this is a review, 337. ITC is a federal agency. It's quasi-judicial. It handles a wide range of matters, all centered around unfair trade practices. What they're commonly heard about is the IP disputes, the 337 disputes, but this ITC is charged with handling any kind of unfair competition that involves imports into the United States. It's unique in a lot of ways. One of the ways it's unique is that it has in rem jurisdiction about imported goods. So the remedies that we'll talk about a little bit later, there's no need for personal jurisdiction over particular parties. They can issue orders that are directed to just the goods themselves that are infringing. Next slide. For a violation at the ITC, particularly for IP issues, including trade secret issues, there has to be an imported article that's jurisdictional, that the sale or the importation of that article is based in somehow an unfair act or a method of competition. And method of competition is particularly broad. It could be in any unfair method of competition, and we're going to focus on trade secret misappropriations today. There also has to be, which is not typical, which is not a requirement in district court cases, the existence of a domestic industry that would be injured, destroyed, or substantially injured or prevented from forming as a result of the unfair act. And then for certain IP, including trade secret misappropriations, there has to be a specific injury or the threat thereof to DI. And we'll go into a little bit more of the details of DI and also what's required for different types of IP violations.
Hey, Kono, it's Brian. I'd love to just jump in here real quick. For the folks who are watching this, I think it's important to highlight something here. And that is that I think many people think of Section 337 really as just kind of another type of patent litigation, because I think it's often patents that are before the 337, of course, not uniquely so, but people think about it as, oh, it's just IP litigation. But I think it's really important to highlight Section 337 is a trade remedy. It is a trade matter. It's not just some intellectual property litigation. And that's important because I think sometimes you hear people scratch their heads and wonder, well, wait a minute. Like, for instance, with the SK LG Chem case, people will say, why are there two Korean companies who are suing one another at the ITC under Section 337? And that's not really what was happening. To your point, the ITC has in rem jurisdiction. So it's not a case about SK or a case about LG Chem. It is a case about specific products being imported into the United States and whether those products infringe on US intellectual property or otherwise constitute an unfair active practice. So it is the reason why you have to show an imported article is because it is a trade remedy about imported goods. It's not a litigation between two parties. That's why you always like the weird names of these cases, in re, battery parts from so-and-so. So I want to highlight that for everybody so they get themselves in the right mindset that this is about trade, not just intellectual property litigation.
Thank you, Brian. So one other administrative issue that I failed to bring up in the beginning. If you have any questions, please use the chat function, and we'll try to address those questions throughout the presentation. So feel free to submit those. And also at the end of the presentation, you'll have a CLE code that you can use with respect to a form that we'll email around for CLE credit. So next slide 6. So as far as DI, this is again a unique aspect of 337 litigation before the ITC. The complaint has to show there's an existence or the process of establishing a domestic industry with respect to the IP rights. Now it's a little bit different for trade secrets. That's true. That's generally true for like patents, trademarks. That is true for trademarks and patents and copyright. And for those types of statutory subject matter, IP-wise, DI requires both a technical and economic prong. The technical prong largely means that the owner of the IP has to exploit the IP in the United States. But that requirement is not true for trade secrets. There's no requirement that the trade secret holder actually use the trade secret in the US. So it's pretty broad in that sense. For trade secret violations, there's no requirement that the trade secret is actually being used by the owner. And the economic prong is a requirement both for statutory IP as well as other violations for unfair trade practices, including trade secrets. And generally speaking, for trade secrets, there has to be some investment in plant and equipment, labor and capital, or some exploitation or R&D with the domestic industry. So let me give some more concrete examples. So complainant making, for example, wheels for a train, if they have a trade secret, they don't have to use the trade secret in their domestic activities. They can assert that trade secret, file a misappropriation of the trade secret with respect to any importer, but all they have to do is show for DI is they invest in the US for train wheels, even if it's not using the trade secret itself. So it's a little bit different than the classic statutory IP assertions of the ITC, for example, patents, which require the technical prong. For trade secrets, there is no requirement for the owner to use trade secret in the US. So again, there's many aspects of trade secrets are very broad. This is one aspect of no requirement for a technical prong analysis. Next slide. David.
Sure. Thank you, Kono. My name is David Vondel. I'm a partner in the IP group at Akin Gump in Washington, D.C. I'm going to handle the next few slides and a few more later down the road. So one of the key things about Section 337 investigations at the ITC are the remedies. And they really come in two different flavors. There's an exclusion order and there's a cease and desist order. And that exclusion order separately comes in two separate flavors. There's a limited exclusion order, which directs the United States Customs and Border Protection, CBP, to exclude the infringing articles that are imported into the US by the named parties to the investigation. So if the parties are named in the investigation, then their products can be excluded from entering the United States by CBP. It's like a big wall comes down around the border, and those products are no longer allowed to be imported into the United States. Another flavor of exclusion order is called a general exclusion order, and it's a little more difficult to get. This would be for all infringing products, regardless of the source. It doesn't matter if it's a named party or not. It just matters that these articles are infringing and they're coming into the United States. But in order to get a general exclusion order, you have to show one of two things. Either that it's necessary, this general exclusion order is necessary to prevent circumvention of an exclusion order that are limited to the named parties, or there's a pattern of violation and it's difficult to identify the source of the infringing articles. So, and it's a relatively high burden to meet, but it is doable. It has been done more frequently in the last few years to get a general exclusion order. So those are the two flavors of exclusion orders that are out there. The second major remedy that the ITC can issue is a cease and desist order. And a cease and desist order is directed to the domestic respondents, the domestic violating parties whose products are found to infringe. And it is directed to certain actions that they can take with respect to those infringing articles that are already in. And so in other words, there have to be commercially significant inventories of those products in the United States, and the named domestic parties can no longer sell those products in the United States. They can no longer market those products. And there's some other activities as well, but it really just kind of puts a clamp on what can be done with those inventories of infringing products that are already in the United States. So you're getting the products before they come in the United States, and you're getting the products once they're in the United States, and there's commercially significant inventories of those in the United States. And then one key part about the ITC is the ITC has no authority to award money damages. Typically, in most cases, what you see is there is a parallel case filed in the United States District Court, and then there is the ITC complaint that's filed, and the ITC complaint goes forward while the District Court is stayed by statute. So if the complainant is interested in going back and getting monetary damages, they'll have to do that in District Court after the ITC proceeding plays out. Next slide, please. Typical timeline in an ITC investigation is it has to be resolved within the earliest practicable time, which is within the statute. The 19 USC 1337 says the commission has to resolve it as early at the earliest practicable time. Typically, in most investigations, 337 investigations, that means that the commission will issue its decision within 16 months. So what that means is there will be a complaint that's filed. 30 days later, the ITC, the commission will decide to institute the investigation. And then 16 months later, the commission will issue its final determination. In between that time, in between those 16 months, there's going to be typical fact discovery, expert discovery, things like that you might see in a typical litigation. And there's going to be a trial in front of the administrative law judge, usually about 10 months after the institution of the investigation. The ALJ will issue an initial determination about 12 months after the institution. And then 4 months after that ALJ determination, the commission will issue its final determination. That 16-month date can slip depending on how complicated the investigation is. If there's a lot of issues, a lot of parties, there's a number of reasons why it could be extended. But on average, most investigations, no matter how many parties are involved, no matter how many respondents are named, they're going to try to resolve it within 16 months. After that 16-month, there's a 60-day period called the presidential review period, where any remedial order issued by the commission can be disapproved of by the president for policy reasons. And this function about 15 years ago has been delegated to the United States Trade Representative. And while it's not we'll talk about this a little bit later, but while it hasn't had, it's been exercised in several investigations, some going back 40 years, and most recently, about a little under 10 years ago, it's still a vehicle as a way to get the ITC's remedial orders overturned.
So we're going to briefly touch upon just the elements or what trade secret is, and then trends in the ITC, as well as to some extent in district courts as well. Next slide. So a high level trade secret is any practice or process an entity has that gives it some competitive advantage over its competitors, and it's secret. So it's not disclosed to the public by any means. So the most classic examples people refer to is the Coca-Cola formula. It's been a trade secret for over 120, 30 years. The search algorithm for Google is always evolving, but it is kept as a trade secret. WD-40, I didn't know this until recently, is a trade secret, the formula for that. And then more generically, pricing information or customer lists can be trade secrets as well, as long as they're kept or not disclosed. So the ITC applies the federal common law for trade secrets. Each state has its own trade secret laws that are usually based on the Uniform Trade Secret Act. 48 states use that standard, plus the District of Columbia. 2016, the federal government enacted the Defend Trade Secret Act of DTSA that is very much follows closely what the Uniform Trade Secret Act has. It's a bit broader in some ways, and for purposes of this discussion, we outlined what the DTSA, how it defines trade secret, and likely, although the ITC has not specifically embraced this statute, because it is like the UTSA and the other states, it's certain that the ITC will apply something akin to what's called for in the DTSA going forward. So it broadly defines trade secret to encompass all forms and types of information, financial, technical, or otherwise. And that can manifest in a number of different ways. And that last bullet just is to illustrate some of the different ways in which it could be. It could be computer code, it could be lists, it could be customers, patterns, graphically, physically, or otherwise. It is anything that gives the company some competitive value, and then as long as it's maintained to be a secret. Next page. So just going back to the DTSA, there's just two requirements that the company or the entity owner takes reasonable measures to keep that information secret by virtue of NDAs, locking it in a safe, like, for example, the Coke formula is locked in a safe somewhere, restricting access to the information, being consistent about policing access to the information. So there has to be a showing that there is a system for keeping it secret, and that the owner does it consistently. And then the other element is that the information has to derive some degree of economic value to another person who could obtain that information. Again, the DTSA is very, very akin to trade secrets at the state level, and the federal common law is used by the ITC. And none of the statutes are preemptive of the other. So in certain cases, more than one statute could be applied given the circumstances. Next slide. Oh, and as far as one other thing before we go to the next slide. One data point that is of interest here on the trade secret is there's an estimate that there's about $500 billion of trade secret misappropriation every year in the United States. The trade secret market itself is valued at in excess of $5 trillion in the US, 5 trillion with a T. And the misappropriation is significant. So it's not surprising that we're seeing, and we'll talk about it later in the presentation to some extent, and David will address it now, we're seeing an uptick in both trade secret litigation, both in district courts and the ITC, and we think in all subject matters, not just the tech space, but also in life science space and other financial industries as well. So we're seeing a lot of activity in this space, and we think with global competition, it's going to continue. We'll address some motivations for why we think it's going to continue. But where it happens the most so far, about 80 to 90% of the cases. It occurs when there's some relationship issue. In essence, the trade secret owner partners with the third party, and the third party misappropriates trade secrets, or its licensee misappropriates the trade secrets, or a former employee misappropriates the trade secrets and brings it to a new employee, or some violation of an NDA agreement. So if you have any circumstances surrounding those types of relationships, and you suspect something, there may very well be a trade secret violation in those facts somewhere. But right now, the majority of the cases are of those type of former relationship, either a partner or employee, and or a violation of an NDA, and less so currently with some kind of cyber security breach, where a trade secret is breached via some kind of intrusion into a computer system or something. But I suspect we'll see more of that too as time goes on. Next slide.
Okay, before I start addressing this slide, there is one question in the chat. Did Akin have a role in the LG Chem SKI ITC case? The answer to that is we did not represent any of the parties in the underlying ITC investigation. We were involved in the presidential review period, which we'll talk about towards the end, probably in a few minutes, as soon as we get through these next few slides. Trade secrets investigations, as we talked about at the top of the call, the complainant does not have to show that there is a technical, that there has been that they do not have to show there's a technical prong requirement that's been satisfied. In patent cases, you do have to show there is a technical prong, meaning that the patent has been exploited and that there are products or the methods that are described in the patents are used in products. But in trade secret cases, that is not required. There's no requirement that the actual trade secret be used in the United States or otherwise exploited. But in a trade secret case, the complainant has to show that there has been an injury to a domestic industry. And Kono mentioned what you may show to kind of demonstrate that there is a domestic industry in the United States. The type of injury you may expect to see could be things like complainants lost sales or underselling by respondents, the reductions in production by the complainant, lost profitability in sales, things like that. So you might show that there's been an injury to a domestic industry in a trade secret case, but in other forms of IP, patents, trademarks, copyrights, there's no need to show an injury. You just have to show there is a domestic industry. So that's one sort of nuance in the trade secret part, where you do have to show the injury, which isn't present in some of the other forms of IP investigations that you might see at the ITC. And then finally, what's kind of interesting about this particular case is this involves two Korean companies based in Korea, where all of the activities occurred in Korea. All the alleged misappropriating activities occurred in Korea. So, and this is consistent with what we've seen in recent trade secret jurisprudence in the ITC, is that when the activities that underlie the alleged misappropriation occur exclusively abroad, the ITC has jurisdiction over the case, as long as there's product that is kind of mentioned at the top of the investigation, at the top of the webinar, that there is a product that's imported into the United States, then the ITC has jurisdiction of that, even if every single act that's alleged to be constituting the trade secret misappropriation occurs overseas. And then we mentioned the Tian Rui case, which we'll talk about in a little bit, but that's another case where all the activities occurred in China. That was a Federal Circuit decision more than 10 years ago, where the Federal Circuit affirmed that there was jurisdiction in that situation. Next slide, please. And this is sort of what we're seeing, the trends and at the ITC, and why there may be an increased number of trade secret investigations at the ITC. Again, compared to patents, which are the dominant form of IP investigations at the ITC, there has been an uptick in trade secret investigations in the last 5 years. There's about 15 investigations that have been filed based on trade secrets alone. The 5 years before that, there were only 5. So there is a triple the number, 3x, I guess. And just in 2020 alone, there were 5 trade secret based investigations that were filed in the ITC. So there is an upswing there. And I think that's consistent with what we're seeing, not just in the ITC, but in district court as well, where there's an increase in trade secret cases that are filed there. And there's a number of reasons why that may be happening. First of all, trade secrets, they can last forever. Unlike a patent, which can have a term of 20 years from the filing date of that patent, trade secrets can go forever. There is, as I mentioned, extraterritorial jurisdiction over the acts that are alleged to be considering the misappropriation. The ITC does issue a remedial order relatively fast compared to district court. As mentioned a few slides ago, you typically get a remedial order from the ITC within about 16 months. District court is probably going to be several years, depending on which court you're talking about, but it's going to be a little bit longer, at least, than the ITC. With the enforcement of those remedies by CBP and the ITC, if there is a violation of those orders, there can be pretty significant monetary sanctions that can really add up pretty quickly, and it's a per day sanction. So if the violation's been going on for 30 days, there's 30 days of sanctions right there. And one thing that Kono's alluding to on the previous slide was about just the sheer amount of trade secret theft that could be going on, is believed to be going on in the present day. There is a greater national attention to protecting U.S. technical and competitive advantages that are based in trade secrets. So there is some national security interest there as well. And then some other issues as well. In the patent space, there's a big controversy over what may be patent eligible and what may not be patent eligible. That's not an issue for a trade secret. As long as you meet the requirements that Kono mentioned on the previous few slides ago, you'll be able to show that there is a trade secret that is protectable, and that's all you need to show there. The ITC investigations are generally not going to be stayed because the ITC has to be resolved at the earliest practicable time. And there's, unlike in patents, where there can be invalidity challenges and at the USPTO and at the Patent Trial and Appeal Board, that's not going to be the case in the trade secret investigation. And also, unlike patents, there's no public disclosure in trade secrets. So by definition, the trade secret has to remain secret. So you're not going to find trade secret information that's going to be released to the public. Hopefully not.
Yeah, and as David pointed out, the monetary sanctions at the IT are extreme. They are definitely punitive. So he mentioned that it's day-by-day sanction. It's either twice the value of the imported goods that violated the remedy or the exclusion order, or up to $100,000 a day. The greater of the two calculations. So it's a very strong remedy with quite a bit of a bite that's enforced by the ITC and customs, and not in essence, in district court, the individual IP holder or trade secret holder has to police it themselves. Here you have these two government agencies doing it for the owner with significant sanctions if there's any violation.
Yeah, and then just one final point on this, just to kind of, as part of the trend line, there have been 4 commission decisions in trade secret investigations in the last 6 months, which is, I don't know if that's an all-time high, but it feels like an all-time high. So it's pretty rare for the commission to issue a full opinion on trade secret issues, and they've done so in the last 4 times in the last 6 months. So it's consistent with the trends that we're talking about here.
All right. And as far as the outcomes of those cases, I guess there were 2 no violations, one of which being the one no violation, 1 remand, and 1 found violation, and then 1 default judgment, which we'll talk about in a moment about the LG Chem case. So there's it's all over the map as far as outcomes. Okay, so we're going to just give a little discussion about the LG Chem SKI investigation 1159. This is a trade secret case, and it's the most recent decision from the commission on trade secret, but largely it's a sanctions case. But we thought it was relatively rare. Like I said from the beginning, the commission has sanctioned other parties in the past, let's see, 5 or 6 years, and with the sanction being a default judgment. So it happens, and it happens but doesn't happen too regularly. So here we have the case where it's the most recent default judgment, and it involved trade secrets, and also involves the more typical trade secret case where former employees or former employees of the trade secret holder went to another company and allegedly took those secrets with them. So in the 1159 investigation, LG was the trade secret holder, and the trade secrets involved lithium ion batteries and a very a market or domestic industry that's of very much of interest with the executive branch of the government and just the U.S. Economy as a whole is electronic vehicles. So this particular case had a lot of exposure and a lot of interest, not only by the parties and the suppliers and the downstream customers of the parties, but also more globally at a national level. So there was a lot of input on public interest from both federal and state governments, others in the industry, the USTR weighed in, the presidents, and I think, as Brian will talk and Steve will talk about, there were at least 13 other government agencies involved with the ultimate decision here. So this case had a lot of interest, and it illustrates that the multiple facets of ITC litigation is not just before the ALJ, the administrative law judge, and the commission. It also involves at least two branches of government, endless number of government agencies, both state and federal, and then whatever industries affected themselves, the participants in that. So the facts here were, as I noted before, LG had trade secrets regarding lithium batteries that were used for electronic vehicles, EV. The only claimed violation was allegation was trade secret misappropriation by SKI, and about 80 employees left LG and joined SKI, and that was the substrate for the conveyance of the trade secret information. This was instituted, the investigation was instituted last year, or 2 years ago in June 2019, and the final commission opinion came out in March of this year. Next slide. Just a little bit more background on the facts of the case. So LG and SKI had an ongoing dispute in Korea about employees, the recruitment of LG employees by SKI, and violation of non-compete agreements and trade secrets to some extent. So that was happening in 2018, 2019. Before the ITC complaint was filed, LG sent a cease and desist letter to SKI regarding the trade secret misappropriation allegations. On April 30th, SKI received service of the complaint. Both at SKI, the facts are that the in-house counsel issued a litigation hold notice to the SKI employees, and that the same day, employees received additional instructions to delete specific documents. So there was two minds, I think, at work at SKI at the time. In September, toward the tail end of discovery, LG notified the ALJ that that a SKI spreadsheet, they called it the 625 spreadsheet, identified about 1,000 documents that appeared to be related to LG's trade secrets that hadn't been produced to SKI. So the spreadsheet was produced, the 6125, that's just the Bates number, but the underlying documents that were identified in the spreadsheet were not. Next slide. Shortly thereafter, LG filed a motion to compel for production, and through the process, it became apparent that the documents listed on that spreadsheet were not in existence anymore. They were deleted, and the ALJ then had issued Order 13, granting LG's motion to compel and ordered a forensic examination of computers to get their arms around the scope of the deletion of the files. So SKI was required to identify all documents related to SG by October 17th, not just the ones identified in the 625 spreadsheet. A bit later, there was a dispute between the parties about the scope of the order, what was supposed to be done by SKI as far as the examination, and it turns out that in addition to that one spreadsheet, that we've been 6125, there were 74 other spreadsheets that it also listed documents that were to be deleted. So there were basically 75 spreadsheets that listed documents that needed, well, that SKI instructed its employees to delete that allegedly were related to at least LG and particularly and possibly LG's trade secret information. SKI at some point asked for additional time to comply with Order 13, but did not indicate to the judge, the ALJ, at that time that they couldn't comply with Order 13. So they didn't ask for enough time to actually comply with the order itself, and that became, at least next page. That became at least the basis for what the judge ultimately ordered, which was that there was spoliation, and that SKI violated Order 13 and was contempt for that. And as a sanction, because the ALJ and as well as the commission thought it was appropriate in that they could never get their arms around what was actually destroyed, and the alleged conduct of SKI as far as seemingly intentionally destroying all this information, they issued as a sanction a default judgment, and they thought that no other sanction would be appropriate to remedy the situation. So as I said from a little bit earlier, this is not unheard of at the ITC, and it's happened probably in the last 5 or 6 years, 3 or 4 times. But this is, by all accounts, a relatively extreme case. Okay, next slide. Okay.
All right. Very quickly on this one, basically both the ALJ and the ITC said that we can sanction a party either under a rules-based way to go forward under the commission rules and federal rules of civil procedure, Rule 37, for violating a discovery order, or based on the commission's inherent authority to do what it wants, independent of any kind of rules-based authority to do so. And the commission looked at both the rules and under its inherent authority and said both of those provide the basis for finding a default under their own separate requirements, and under both analyses that there should have been a finding of default in this investigation. Next slide, please. On review by the commission of the ALJ's decision, the parties briefed the public interest factors pretty extensively. There were arguments that suggested that the Ford and Volkswagen plants in the United States that relied on these SKI batteries are going to be built in the United States. Those factories would have to close because they wouldn't have the batteries to put in the cars, and that banning SKI, their products, would conflict with domestic economic and environmental policy promoting the adoption of electric vehicles. And the commission just outlines everybody who submitted a public interest statement, all the third parties that did so, and it involved auto and component manufacturers, many members of Congress in a number of states, suppliers to SKI's Georgia plant, and Georgia's state and local governments and utility suppliers. Next slide, among others. About 3 months ago, a little over 3 months ago, the commission issued its opinion and the remedial orders. They issued a 10-year limited exclusion order and cease and desist order on SKI batteries being imported into the United States along with certain components. But there were carve-outs in the limited exclusion order. so that SKI could fulfill its contractual obligations to Ford and VW for a short number of years for each, 2 years for Volkswagen, 4 years for Ford. The commission said the ALJ's finding of fact were correct, but clarified how they got to a default. And it looked at both of those rules-based applications that I mentioned earlier, that because SKI failed to apprise the ALJ of the full scope of the spoliation, the destruction of the documents, and why, the commission said under that rule-based analysis, that was enough to find default judgment. And under the inherent authority analysis, all the elements of spoliation was met, and therefore that was sufficient to find default under the inherent authority as well, based on SKI failing to preserve evidence that it seemed like, at least according to the ALJ and the commission, that the SKI was destroying documents with a culpable state of mind, and that these documents that were destroyed seem to have direct relevance to LG's trade secret claim. Next slide, please.
Okay, I think that's my cue. I'm Brian Pomper. I butted in a little bit earlier on the trade piece. I'm co-lead Akin Gump's lobbying practice. I am by training an international trade lawyer, but I also have the weird credential for folks who are trade lawyers that I have an engineering background and I'm a member of the patent bar. So I have done quite a few of these type of public interest factor cases because they intersect between the international trade and intellectual property expertise. So we've talked about how the flow of a case, we've talked about the flow of the specific LG Chem case, you've got the ALJ decision, you've got the commission decision, and then it moves to the public interest review, where the president has 60 days to decide what to do, but Steve will talk about that in a minute. But just to touch on them very quickly here, the public interest, remember this, as I said, this is a trade remedy statute, right? This is not a strict liability. Are you infringing the intellectual property or not? It's a trade remedy statute. And in that regard, it's about what's best for the US economy as a whole. What should we be doing to protect the US economy from, in this case, unfair acts or practices? And so part of what the commission will look at during the course of the case and the president will look at deciding whether or not the remedy that's recommended should go into effect is, how is the public impacted by the decision that could be made here in terms of excluding a certain type of product? By statute, the main public interest factors are, as we list here, the public health and welfare, competitive conditions in the US economy, the production of like or directly competitive articles in the United States, and the impact on US consumers. Those are the statutory requirements, but there are also other factors that could be taken into account. Again, the idea is trying to look holistically at, is the public interest in the United States served by having an exclusion order go into effect? With the background understanding that, and the first order understanding is that the public interest is served by stopping infringement in the United States. So that's kind of the first, the way that the commission is going to think about this, is that, the public interest is served by preventing infringement in the United States, but there might be other important public interest factors that could overlay that and make it so that you really shouldn't have an exclusion order in a particular case. Or during the course of the case, as the ITC is looking at the violations and considering the public interest factors and thinking about the various parties who have weighed in and expressed concerns on one or other of these public interest factors, the ITC won't just do a black or white, yes, we're gonna entirely block all products that are under investigation, or we're not going to block them. They could tailor the remedy in order to try to alleviate some of the public interest concerns that have been addressed. And you saw in the LG Chem case in particular, there was an attempt by the commission itself to modify the way the exclusion order would work, to give some time to allow there to be adjustments made and for contracts to be fulfilled. I think Steve will talk a little bit more about that. But when we think about the public interest, it is really in the interest of the parties before the commission to make those arguments really from the get-go and keep hammering them, remain consistent during the course of the case, try to develop other parties, not just before the case, but other other people, downstream suppliers, the local officials who might be impacted by whatever the exclusion order is, other interest groups that might be interested. Maybe there are health groups if there's a public health or welfare issue. Maybe there are antitrust groups if there's a competitive question. There could be other types of third-party non-governmental groups or policy groups or even political groups who might have an interest in a particular outcome in a case. Work with them, get them to write letters, to contact the Hill, get the members of Congress involved, develop who it is that you're trying to go see, and try to educate the commission on all of these factors throughout the case. The commissioners themselves are following the law, but the truth is that they are human beings and they will see the facts and the law perhaps in a particular light in how they are living in the world around them. So if they are picking up the newspaper every day, for instance, and they're reading stories about how terrible it would be if there were an exclusion order in a particular case, and this does happen, that might impact their way of thinking about this particular case. It may make them a little bit more cautious if they see big name people criticizing what perhaps the ITC can do. So I don't mean to say that they were not going to follow the law. I just mean to say that they are humans. And the goal of the people who work in public interest is to try to present the case to the commissioners in a particular way so they view it the way that we would like them to view it. Next slide.
So my name is Stephen Coe. I am a partner here at Akin Gump, and I lead the trade policy practice in the international trade section. I came from USTR, and when I was there, I actually ran the presidential review process. Brian and I get called in quite often by either our team here at Akin or even working with other law firms who are the 337 councils to deal with the presidential review and deal with public interest. As Brian said, the public interest factors and the considerations, in the old days, it used to be only when you get to the presidential review, the last 60 days. When almost everything's said and done, right? And the ITC has basically come out with its recommendation on action, its decision, and the president is hamstringed really by what he can do. Either it's a yes or no, it's an up and down vote at that time. But over the course of the last 15, 20 years, public interest has now become very much a part of the ALJ process, the ITC process, and that's why we talk about and we get brought in earlier and earlier to help formalize and finalize the public interest arguments early on so that it can have an impact. It's still the same. When you get to the presidential review process, the president only has an up or down vote. So therefore, when we get there, it really is sort of the last hurrah, your Hail Mary shot. We would rather not get there and try to get that issue, but this is the issue we faced when we were involved in the LG Chem case. We represented VW in that case, and in that process, through the public interest arguments before the ITC, we were able to make good enough arguments about the need from a public interest point of view to craft your remedy in a way that allows for a carve out for VW. What ended up being the carve out, and this is part of the problem with the ITC process still, is if you're not a regular party, you don't have actually a say in the remedy process. You sort of have your say as a third party, but then you're not involved in some of the discussions and the consideration of the actual remedy. So what ended up happening there was a remedy, a carve out for VW for 2 years and a carve out for 4 years. That was neither one was sufficient really for the company's issue, and so therefore we kicked it into full gear during the presidential review process. So the process really is, as it shows on this slide, is for public policy reasons. It is for the full trade policy staff committee, TPSC committee to consider. USTR takes the lead on that process. It runs 60 days. It really only runs 6 weeks. And the last 2 weeks is just internal sort of administrative process, putting together the memos and everything going up to the president. So it's a very truncated time in order to get your issue across. It used to be the that USTR at one point tried to implement more of a formal process where you would come in and you would have these formal meetings with the TPSC, be more like a hearing. It's gone back to being much more sort of loosey-goosey. You sort of engage with the agencies that you need to engage with, and things like that. And sometimes some of these agencies, we'll see in the next slide, that every agency is involved in the TPSC, but not every agency participates. It's a matter of choosing the right agencies for the right cases and the right issues, and sometimes even educating those agencies because they haven't participated in 337 in years, or just have somebody new. As I said, and as other people have mentioned, the presidential reviews are rare, and this is what we had to deal with in the LG Chem case. We thought we had a good public interest argument going in. It was considered at the ITC. That was very helpful. But to actually have the president disapprove, that is very, very difficult. In our process, and what we were making arguments of, it was really all about disapproving simply to fix the remedy, to make the remedy effective and practical. And that was a difficult consideration for the president and the administration. But that was the goal, and that was what we worked hard on, and I think that was what contributed to the outcome of the settlement. Next slide, please. So these are the agencies involved. Not every agency has a vote. For example, the ITC is involved, they don't have a vote. Copyright Office is involved, they don't have a vote. USPTL, DOC, they're both involved, but they get one vote. The way that this works out, as I said before, is you get 3 or 4 sort of main agencies that participate. But then on each case and each particular issue, as it relates to the public interest, you would get more folks involved. In the LG Chem case, obviously, DOT, DOE, EPA all play a significant role.
Right, and Steve, I think that the important point here is it depends what your public interest arguments are, right? If you've got a case that involves a product that could perhaps deal with patients and hospitals, right? You would want to go see the Department of Health and Human Services. In previous cases, when there have been questions about anti-competitive impacts on the US economy, the Department of Justice has been really involved. Often because we're talking about imports that are perhaps important to a foreign country, the Department of State almost always has equities here. So it's a little bit of a fluid situation, which agencies you're going to see and which you're trying to get involved in the TPSC process, depending on what your arguments really are. So, and that, again, that's just by way of experience and understanding. And the goal is really to try to get those agencies to weigh in on your side, whatever it may be.
Next slide, please.
Hi, my name is Suzanne Kane. I'm a partner in the trade practice. And prior to coming to Akin Gump, I used to work at US Customs and Border Protection in the intellectual property rights branch at headquarters. So once an I'll go quickly here because I realize we're almost out of time, but once an exclusion order is issued, it is US Customs that then has the responsibility for actually excluding the goods that are subject to the exclusion order. Next slide, please. So usually goods are just excluded, which means that the importer has the option to export the goods to another country. But there are some cases in which if an importer continues to try to import excluded goods, Customs will notify the ITC, and the ITC might also issue what's called a seize and forfeiture order, in which case then Customs then has the authority to then actually seize goods that are subject to the exclusion order and not simply exclude them. Next slide, please. So there's kind of 2 big processes at Customs that we recommend both complainants and respondents be aware of that can take place after an exclusion order is issued. We did not get to this point in the SKI LG case, but in general, an importer or a respondent can submit a request for an administrative binding ruling from US Customs that a new or redesigned product does not infringe the patent claims at issue in the exclusion order. And CBP in the past couple of years has implemented a new inter partes process for adjudicating these rulings, which is actually very efficient. They generally from start to finish take about 60 days, which is a very quick timeline. But essentially what happens here is an importer can submit a ruling request about their new and redesigned product. The complainant has the opportunity to then respond to that request. CBP then holds a hearing with both the parties present. Both parties have the opportunity to submit post-hearing briefs and then reply briefs, and then CBP will issue a determination. This can move very quickly because CBP is essentially adjudicating one simple issue, which is whether any part of the new or redesigned product infringe any claims at issue in the exclusion order. Next slide, please. But on a more practical note, even if you are not considering requesting a ruling for customs about a new or redesigned product, there are things for both complainants and respondents to think about CBP's enforcement of exclusion orders once they are issued. And consistent with the theme that some others have been talking about throughout this webinar, is that it's important to get in earlier and earlier and earlier, and to think about these factors and start reaching out to customs on the early side if it looks like an exclusion order will be issued. Generally, it's very common for complainants to be reaching out to customs and advocating for the largest possible interpretation of the exclusion order or largest possible enforcement of the exclusion order. And complainants are often monitoring the marketplace very closely and giving customs information about imports that they're seeing in the marketplace. On the other hand, it is a very good opportunity for respondents to go to customs and arm them with very practical information about the products that they import that are not subject to the exclusion order. So when I was at headquarters, my job was to look at these exclusion orders and draft practical instructions to the field, the CBP officers all around the country about how to effectively exclude products. And often that boils down to incredibly practical information that we received from respondents. So especially if an importer has products that imports products that are not covered by the exclusion order, in addition to products that are, it's really important to educate CBP early on the products that are not covered to make sure that your flow of imports is not disrupted, your legitimate imports are not disrupted. It's also important to stay in close contact with customs and update them on changes in packaging, import flows, anything that will help them quickly and efficiently identify products that are within the scope of the exclusion order and not covered by the exclusion order. And here are some examples of helpful information. Customs will really use anything that you give them. Everything is helpful. They want more information. It is in their interest, and they're under a lot of pressure to enforce these wisely and efficiently. So we would just recommend both parties reach out to customs as soon as possible in the process. This is just more information that is helpful to customs when enforcing these.
Great. My name is Julius Chen. I'm a partner in our Supreme Court and Appellate Group, and I thought I would spend a few minutes just talking about what happens next after an ITC proceeding wraps up. And I'm just going to leave you with a few quick points. By statute, all of the appeals go to the Federal Circuit, where we spend a fair amount of time. But as the stats will bear out, there's it's a patent heavy docket at the Federal Circuit, as I'm sure you know, and there are relatively few trade secret misappropriation appeals. There are relatively few ITC appeals to begin with. And so here's a helpful chart, I think, sort of showing the fact that, most of these things don't usually percolate up to the Federal Circuit. But the flip side of that is that there are Federal Circuit decisions that become very significant when they do sort of filter through. And there are a number of unanswered questions relating to ITC investigations that have the potential to be litigated over the next years, as there are increasing assertions of trade secret misappropriation at the ITC. I think the best example of one of these unanswered questions is a foundational one. It wasn't until 2011 that the Federal Circuit said, we're answering a question of first impression. What law governs a trade secret misappropriation claim? You would think that this would have been answered long ago, but they said, as I think David Arcona said earlier, they clarified that it is federal common law. Next slide, please. And so two things just to be aware of, one sort of general and the other a little more substantively specific. The first is that realize that the ITC is an agency, and so ITC proceedings by statute are subject to the strictures of the APA. And so that comes with all of the usual layers of APA review. Are there questions of Chevron deference, which are important here because a lot of the statutory language in section 337 is quite broad. Are you faced with a deferential standard of review of the ITC decision-making process? You know, is the agency's reasoning the one that you are trying to defend on appeal under the Supreme Court's Chenery decision? The Federal Circuit in recent years, particularly because of patent reform, has become increasingly sophisticated in administrative law issues. And so you've seen a trend of sort of more and more sort of porting over of foundational administrative law concepts that are coming more and more to the fore. So I imagine those would come to the fore as well in the ITC realm as well. Moving to the second point, just quickly, David mentioned the Tien Rui case and the extraterritorial reach or the seeming reach of section 337 in these types of cases. And that, again, was a case where all the conduct and the alleged misappropriation happened in China. And there was a split decision with Judge Moore dissenting, who will soon be the new chief judge on the subject, saying this statute doesn't really apply here, and so we shouldn't be talking about this. This is a somewhat settled issue, but it is still percolating. There's been a follow-on case called the Sino-Legend case, which presents one potential expansion. And in that case, interestingly enough, the Chinese government itself said, we find no trade secret misappropriation here. We find the alleged misconduct to be perfectly fine under our own law, and yet there was an exclusion order. The Supreme Court denied cert in that case for a variety of reasons, I think, one of which was that the Federal Circuit chose not to issue a decision. It did something called the Rule 36, where it just enters a judgment that says the ITC's decision is affirmed. So it's not sort of the fodder for Supreme Court review, but this is the type of unanswered question that may continue to come up in the future. And with that, I'll turn it back to David and Kona. Thank you.
Next slide. So yeah, just to have a summary, just some quick takeaways for this. For the ITC, on the enforcement side, as well as on the exposure side, the ITC looks like it's going to continue to be an active forum for trade secret enforcement. As you've heard throughout today's webinar, is some of these, other than handling the merits of the case before the ALJ and the commission, working the other issues with the other agencies early and consistently and at key points is important. So reaching out to customs when an exclusion order looks like it's likely to happen one way or another, depending, doesn't matter what side you're on, working with customs early to get your views on what's likely to happen and how to interpret it, working with USTR, again, particularly if you're on the respondent side facing exclusion order, as well as, marshaling folks from Congress and the industry and state and local governments to weigh in a way that may be helpful for you. So this is it's a complete case outside the actual case on the merits, the public interest and the policy issues. So that's more or less the second and third bullets there. We didn't mention this, I don't think, but in about 50% of the investigations, the commission will delegate to the ALJ to conduct findings of fact regarding public interest. In about half the cases, that will be in the actual investigation itself. But whether or not it is or not, it behooves both sides of the V to work these issues outside the ITC itself. And then as we just mentioned a moment ago about appeals, there's a lot of arguably unanswered questions regarding trade secret enforcement at the ITC. So we're likely to see cases percolate up, as Julius mentioned, and that it's key during the investigations themselves to preserve those appeals and for presentation at the Fifth Circuit, particularly in the area of trade secrets, which we're going to see, we would expect to see more activity, and it is a bit uncharted territory historically at least the Federal Circuit level. And with that, unless David or anybody else has any other points, I think that's the conclusion of our session here. And if there are any questions, we can try to handle them now. If there's any.
There's one question, Kono, about whether the slides will be sent out afterwards, and the answer to that is yes, the slides will be sent out. Otherwise, that's everything in the chat box right now.
All right, thank you very much. If you have any questions you want to follow up with any of us, there are contact information on one of the tail end of these slides. And thank you again for your time. Good day.